name is Lynn Garcia, and I'm the General Counsel of the Texas Forensic Science Commission. And today I'll be talking to you about the importance of high-quality forensic science in ensuring justice in criminal cases. I know for a lot of folks, their exposure to forensic science is what we see on TV, CSI shows, and things like that, where really cool scientists have this amazing technology and they're trying to solve crimes, and they put information into these computers, or they look at things under the microscope, and within 30 minutes or an hour, they've solved an entire mystery, and they know the answer without, beyond any shadow of a doubt, and the bad guy is caught and the good guy goes free. What I want to talk to you about today is what the reality is in forensic science. And the reality is that forensic science is a critically important tool in law enforcement and in criminal justice generally. But what you see on TV and the reality are not the same. And so what we need to do is understand, as people out there in the community who may at some time be affected by a criminal justice system, whether just because we serve as jurors or because we become lawyers or members of law enforcement, or we're working in crime labs, whatever your interests might be, it's really important to understand both the power and what can go wrong when forensic science isn't applied properly. So that's what I'm going to talk to you about today, using some examples that we've run into at the Forensic Science Commission. So I wanted to talk to you just a little bit about our commission. We were created back in 2005 by the Texas legislature in the wake of a scandal that happened at the Houston Police Department crime lab. In that particular situation, the DNA lab was operating so poorly that there were actually a couple of people wrongfully convicted based on the results that came out of the DNA laboratory. And this was a huge wake-up call and a shock to a lot of people in the world of criminal justice. And as a result of that scandal, the Texas policymakers decided that we needed some oversight for forensic laboratories, and that's how our commission was created. So our commission consists of 9 people. 7 of them are scientists and 2 are attorneys. They're all appointed by Governor Abbott, the governor of Texas. We have lots of different responsibilities at the commission. We accredit the crime laboratories themselves. We conduct investigations when the laboratories have perhaps made a mistake or they're being accused of making a mistake, whether intentionally or not. We investigate the labs based on either their own self-disclosures of problems or things that are brought to our attention by the National Innocence Project or attorneys in the system. We take a look at those problems and try to figure out how to make things better. We also license forensic analysts. So if you're familiar with lots of different occupations require licenses, even if you go to get a haircut, you can see on the wall that there's a certificate that the barber, the hairdresser, the hairstylist has a license. So we do that for forensic analysts. Policemen have licenses, lawyers, doctors. And what it does is it sort of gives a framework for what we expect of the profession. And we also work collaboratively with the Court of Criminal Appeals and other parts of the criminal justice system to provide training and education. So we work with a lot of other agencies. We absolutely are in the business of trying to solve problems, not blaming people or reinventing the wheel, as some say. And because of that, we are really, when we see an issue, no matter how heartbreaking, for example, forensic science and a wrongful conviction, where we see how the problems break down, what we're really trying to do is make it better for the future, so that that can't happen again to anyone else. And just to be clear, if you watch shows on TV, or if you've experienced this in real life, that our criminal justice system is adversarial. So you have the state versus the defense, and they're arguing with each other, and they each have their own theory of the case, and they each have their own role, and they're trying to convince the trier of fact, either a judge or a jury, that their version of events is the right one. And whether that be that a defendant is innocent or guilty, ultimately the jury decides that in a lot of violent crime. And so we understand that everyone, no matter who you are, whether you're a member of the public or a lawyer or a scientist, everyone wants the criminal justice system to work. No one wants to see innocent people convicted, and everyone wants to see justice for victims, especially innocent victims of violent crime. So trying to make the system work for that, our job at the commission is to try to help that, specifically in the area of forensics. So I'm going to talk to you today about two different types of forensic science. One is the analysis of blood stain patterns at a crime scene. And then after that, I'm going to talk to you about DNA analysis. And in both of these examples, there are situations where the analysis that was done had problems with it. And those problems led to an erroneous outcome, or at least in part contributed to a wrongful outcome where someone was convicted where the science did not support the ultimate result in the case. So I'm going to talk to you about that. So this is our first case. It involves a high school principal in Clifton, Texas. His name was Joe Bryan, and here he's pictured. Mr. Bryan was convicted of murdering his wife, who was a school teacher in the local school system. There was, leading up to the homicide, there was no indication of conflict between the couple. All their friends and loved ones said that they had a very harmonious relationship, that they were best friends. They didn't have children. Ultimately, though, Mr. Bryan was convicted of murdering his wife, and this was way back in 1985. So as I said, Mickey Bryan was an elementary school teacher and Joe Bryan was the principal at the local high school. Mr. Bryan was actually in Austin at a conference for principals at the time that his wife was murdered. They last spoke, according to hotel records, at 9 o'clock on the night she was killed. And he was seen at the conference in the morning at about 8 a.m. She was shot 4 times in her home in the bedroom. The crime scene was very bloody. The state's theory of the case was that Mr. Bryan, after having spoken with his wife, left Austin, left the hotel here in Austin, drove to Clifton, killed his wife, and drove back to Austin in time for the start of the morning conference session about 8 a.m. So the local law enforcement did not have a suspect shortly after the death of Mrs. Bryan. Her brother came to Texas, brought with him a former FBI agent who turned into a private investigator, had retired from the FBI and was now a private investigator. This was to try to supplement the investigation by local authorities who couldn't turn up any leads. The brother and the agent, the PI, borrowed Mr. Bryan's car and drove around trying to find some clues about, who could have killed Mrs. Bryan. At some point, they say they pulled over to relieve themselves in the woods and got mud on their boots. And their explanation was that they opened the trunk to try to find something to clean the mud off their shoes. And when they did that, they found a flashlight with what they thought was specks of blood on the flashlight cover. And so this was sent to the state lab. The little brown specks on the spotlight were tested on the flashlight, and the results were positive for human blood. And it's type O, which is the most common type of blood in the population. So here's a photograph of the actual flashlight that was recovered from the trunk of the car. So this information was brought to the attention of local law enforcement. They contacted a nearby county where there was a police officer who had taken 1 week's worth of courses in bloodstain pattern analysis. This homicide was his very first bloodstain pattern case in his entire career. He looked at the flashlight, claimed the pattern on the flashlight was back spatter from a bloodletting event. And basically what that indicates is that blood traveled backward at high speed from a target. So if you shoot, in this case, the body of Mrs. Bryan, the blood comes flying toward the flashlight and makes this pattern. Backspatter is known within the community of people who perform bloodstain analysis as typically consistent with a close range shooting. And this was what the medical examiner had said, was that Mrs. Bryan was shot at close range. Mr. Thorman, the analyst who looked at this was his first case, testified about lots of different things, one of which was that whoever was holding the flashlight, however the flashlight was sprayed with the blood had to have been because somebody was holding it, and they were holding it at close range when they shot Mrs. Bryan, and that it was both present at the crime and held by the killer during the shooting. So these are a lot of different areas of speculation that this particular individual engaged with and testified to at trial. So this is a photograph from the crime scene, and those rays of sort of what it looks like light, but what it actually is string, where the analyst sort of drew, using this string, tried to make determinations about directionality of the blood and where it all originated from. So this was a system that he used to try to figure out what had happened based on the blood stains. Now, we looked at this case after the fact, long after the fact, and there are a couple of things. One is that we don't comment on guilt or innocence. We look at the science and only the science. The criminal justice system and the courts are responsible for assessing people's cases on appeal, or if they bring a writ arguing that there's new evidence that indicates their innocence. We don't deal with any of those determinations. We're not a court of law. We just look at the scientific issues in the case. So we retained 2 different experts to take a look at what occurred here, both of whom concluded that there were many problematic aspects of this analyst's testimony. The stringing procedure revealed, the one that I showed you with the last photograph, there were lots of different examples of error there. He used an inadequate sample of blood stain to assess where the area of origin was. He testified outside of his area of expertise. Essentially, he said that the killer must have cleaned up and changed clothes because there wasn't blood tracked all over the house in the way one would perhaps expect for a bloody crime scene like that. And this was essentially speculating that the person who killed Mrs. Bryan must have known her and known the house so that he could go and change clothes and change shoes and all of these sorts of things. None of that is the type of thing that a bloodstain pattern analyst or a scientist of any kind should be speculating about, but yet he did that at trial. His testimony about the position of the victim's body was unsupportable. Also, it was fundamentally inappropriate to classify those specks of blood on the flashlight that I showed you as spatter, given how tiny those specks were and the fact that it was totally disconnected from the scene when it was found. So you have no way to even assess the chain of custody of that flashlight, who else had it, what the context was. It was found in the trunk of the car. there are lots of explanations for how it might have gotten there, or for how those specks might have gotten there. It was inappropriate to conclude the killer was carrying the flashlight in his hand. He failed to account for how variable the distance that blood can travel through the air is. And in the end of our work, and in the end of the re-examination of Mr. Bryan's case before a court, ultimately this analyst who had testified back in the 80s, he's still alive, and he recanted his testimony. So the lawyers for Mr. Bryan approached him and said, we have the expert, his name's Tom Bevel, who trained you back in the 1980s, who is looking at this and saying that you really didn't know what you were doing when you testified. And Mr. Thorman, to his credit, signed an affidavit that was submitted to the court recanting what he had said and acknowledging that he was outside of his area of expertise when he testified. But saying that he didn't do it on purpose, he thought he was acting in good faith, but he realizes now upon reflection that the things he said were not backed by science. So this is March of 2020. Mr. Bryan was released on parole, and this is him leaving TDCJ. So when we see errors like this in the system that contribute, now I should be very clear that it's rare that one particular thing in a case is what can be blamed for someone being wrongfully convicted. It's usually a convergence of various factors: eyewitness ID, testimony that's incorrect, or overstated, or doesn't follow best practices. The forensic science is a component. There are lots of different things that come into play usually when you do an evaluation of someone who is wrongfully convicted for a crime. But we always are left with the question, what should be done? How can we prevent this type of testimony from being offered again so that nobody else has junk science as an element of their case? And so we really looked at the discipline as a whole. How reliable is it? And what we realized in working with a lot of law enforcement who do this type of work, including the Texas Rangers, is that some experts out there will extrapolate far beyond their actual knowledge, because bloodstain pattern analysis is essentially fluid dynamics. It involves physics. It involves all kinds of different scientific disciplines that come to bear in trying to figure out what you can say about a pattern that's left at a bloody crime scene. What information can be deduced from that? For example, if you have a homicide where someone is alleging that they committed the murder in self-defense, what do the bloodstain patterns tell you about whether that defense actually is viable or not? So there's a lot of information that people need to understand, scientific information, in order to be able to, number one, speak accurately about what they're seeing, but number two, be able to exercise the self-discipline required to stop themselves before going too far, going beyond what the science allows. Because oftentimes people want to be helpful. They want to help solve the crime, but it really is not like it is on TV, where the scientist comes in with the golden nugget that solves the crime. And if forensic scientists don't know enough when to stop themselves, they can go overboard to the point where the jury is led to believing that something is 100% certain when it is anything, not even anything close to that. So these are the types of things that we keep in mind when we're looking at these cases. We know right now that if someone looks at a bloodstain pattern, what they can say as a result of that is fundamentally a subjective opinion. It is what they are seeing based on their training and experience. But there's not a lot of data that demonstrates whether or not certain patterns necessarily mean certain things. A lot of the analysts who do this work don't have formal training in physics or fluid dynamics. The complex patterns that fluids make when they're exiting wounds in the human body can be highly variable. The published papers that we looked at were actually not very helpful on this subject. For example, we saw one study where a panel of 27 bloodstain pattern analysts looked at 730 patterns in 2 different phases. One that looked at rigid non-absorbent surfaces, so things like wood or wallpaper. And those surfaces were used to represent commonly encountered crime scene surfaces. And then they also looked at fabric surfaces, things that you commonly see in crime scenes like sweatpants or trousers or denim jeans. And so they looked at these hard surfaces and then also the clothing type material that you see a lot in crime scenes. And they created 6 different types of patterns. What you would see with blunt force impact, also with firearms like back and forward spatter, cast off spatter, which basically is, if you hit something and the blood goes flying from an instrument, how does that work? Stains from dripping blood, and all of this was done in the form of a study to assess how accurate and reliable the analysts were in analyzing them. And what they found was where people did go ahead and make a classification, either by choosing one pattern or nominating more than one, 13% of those cases, the analysts did not pick the right pattern type, and that was on the hard surfaces. And in almost a quarter of the fabric surfaces, they got the answer wrong. So that shows you that what we're talking about here when we listen to an expert's opinion in this particular area is far from what you see on TV, which is that 100% certainty that the actors have. And then they also tried to give, in some of the examples, they tried to give the analysts some information to deliberately point them toward a correct classification. So they're trying to bias the analysts with the type of information they were giving them. And when they gave them the information pointing them toward the right answer, they tended to get the right answer more. And when they pointed them in the direction of a deliberately wrong answer, the misclassifications increase. So what that tells you is the information that these scientists get can point them in one direction or another. And that's really important when you don't know ground truth, which you almost never do about a crime scene. So if I'm an analyst, I'm going to be influenced, whether knowingly or not, by the type of facts that are fed to me in the process of evaluating the crime scene. So that's something important to understand when you think about the process that analysts go through in reaching their conclusions. So we really worked hard on trying to figure out a path forward to minimize things like contextual information or bias, for the analysts to get less information when they're trying to figure out what the crime scene or what the bloodstain pattern is saying. And then also we need a lot more research than what currently exists to understand what steps the analysts take in reaching their conclusions. And there's a lot of diversity among analysts about how things are classified. And there needs to be more clarity on that subject as well. Now, we also take into consideration the practical concerns of law enforcement. So there was a time when we thought, well, we really are concerned about the reliability of these types of analyses. What can people really say from bloodstain patterns. And it was pointed out to us very kindly by the Texas Rangers that we need to understand that there are certain situations like the shooting in Sutherland Springs where they have a very bloody crime scene, and there are basic things that the crime scene analysts need to be able to say and do in order to effectively represent information during trial. And so what we want to do is sort of balance the need to be able to make reasonable deductions from the blood that's found at the crime scene. We need to balance that with our desire to make sure that there isn't misleading or overstated information introduced. And similar to that, if you look at, this is a map of Texas where I am right now, and Texas is a very large and diverse state. And so the law enforcement resources and the scientific resources are not uniform. So one of the things we do is try to make sure we understand that we're not making decisions that are going to put especially the smaller, more rural places in the state in a real bind when they're trying to work their violent crime scenes. So ultimately, the desire is to move away from subjective approaches toward more objective approaches, having well-designed experiments and objective measurements for them. These are all foundational principles in science that we need to make sure exist in forensic science as well. And we need analysts to express the limits of what they're doing. For example, when we say two items are indistinguishable based on certain criteria, that doesn't necessarily mean they originated from the same source, but that's often what juries hear. So we need to be able to help forensic scientists move toward objective criteria when they are doing something that's subjective in nature, meaning that it's their opinion, essentially, their evaluation. That needs to be made clear to the juries so the juries don't misunderstand this scientist's process for what we see when we watch a TV show. And oftentimes juries don't have any other exposure, so they assume that if the person's a scientist, it must mean that they have all that amazing objective technology that we see on CSI shows, when in fact that's not necessarily the case. So that was our conversation about Joe Bryan and bloodstain pattern analysis. And now I'm going to talk to you about another case involving this man, Lydell Grant, who is no longer incarcerated. And Mr. Grant's case, what I want to talk to you about is sort of the nuances in DNA analysis. Now, I think most people, when you think about DNA testing, you think that that is the gold standard. If the DNA says it was him, then it had to have been him. But similar to other areas of forensic science, there actually is some subjectivity in the interpretation of DNA evidence. So I'm going to talk to you about how that impacted Mr. Grant's case. So the key facts of this case is that Lydell Grant was sentenced to life in prison for a stabbing that happened in a Houston nightclub, and this happened back in 2010. And there was a struggle that happened in the parking lot of the nightclub before the victim was killed. So they had a fight. And when the crime scene was worked, they took the fingernail scrapings from the victim. Because when you're involved in a struggle and there's scratching going on, you may get skin cells underneath your fingernails that can be later analyzed for DNA to see whether or not you can deduce who those nails came into contact with, or at least have an idea of what the DNA profile looks like. The evidence from the victim's fingernails was actually reanalyzed in 2019. And the reason that happened was because Lydell Grant had been writing to the Innocence Project of Texas, proclaiming his innocence the entire time he was in prison. The Innocence Project took up his case and sent the results of the fingernail scrapings, so the data, to a company called Truallele that has new and more sophisticated software. And that company looked at the original DNA analysis that was done back at the time of the stabbing and said, wait a minute, there is an alternative suspect's profile here. They uploaded it to CODIS, which is a national database of convicted offenders maintained by the FBI, and there was a hit. And that hit was to someone who had been in Houston around the time of the stabbing, had a very long list of offenses, violent offenses, both in Houston and in other states. He was actually in Georgia at the time that this reanalysis was obtained by the Innocence Project. And originally, the Houston Police Department, back in 2010, had looked at the results of the DNA testing and said that Mr. Grant could not be excluded as a potential contributor to the DNA profile that was obtained from the fingernail scrapings. And when we looked at this case, we realized that that was actually a wrong analysis. He should have been excluded as a contributor, both at that time and now to this day. So the analyst didn't say he was included, didn't provide a statistic, one of those high statistics that you often see in DNA cases, but by saying it was inconclusive and that he couldn't be excluded, it allowed the jury to think, well, maybe it's him or maybe it's not him. And then when they added the other circumstantial evidence that was available that law enforcement gathered at the time, the jury thought that Lydell Grant was the murderer. Now, how did Mr. Grant get on the Houston Police Department's radar as a potential perpetrator of the homicide? Well, there was the Crime Stoppers tip. Mr. Grant admits to this day that he did have some prior offenses, including robbery. And when they picked up Mr. Grant, he had a ski mask and a Halloween mask in his trunk, which did not look good. There were 6 eyewitnesses at the nightclub who, when brought in to do sort of a photo lineup, picked Mr. Grant. So 6 different eyewitnesses. Now, it was a nightclub. The nightclub was named Blur. The stabbing was in the middle of the night. And so their ability to do a good ID, I think a lot of people would say those are not the best circumstances to make an ID. And on top of that, at the time that this lineup was done, the photo lineup, the state of Texas was not yet using best practices in photo identification in lineups. This was right before the Texas legislature passed some rules requiring better procedures for doing lineups. So at this time, an officer could still offer quite a bit of suggestive sort of leading information to a witness to get them to land on a particular suspect. And so when we look back at the process for the lineup in this case, our commission has not looked at it, but my understanding is that this was an example of a suggestive lineup. And as I said, at the time, best practices hadn't yet been adopted statewide. They were adopted shortly after this, but not in time to impact Mr. Grant's case. So as I said, the Innocence Project of Texas sent the data from the original analysis to a company in Pennsylvania. And through an agreement with another laboratory that's a law enforcement laboratory in another state, the data was compared to this national offender database. And ultimately, the Atlanta Police Department, the Georgia Bureau of Investigation, Texas DPS, and the Houston Police Department all worked together and ended up picking up the alternative suspect in Atlanta. After a couple of hours, he confessed to the murder. He was indicted in December of 2019. So this is a pretty dramatic closing to this case for sure. And when we look back at the original DNA testimony, again, the analyst didn't say that Mr. Grant, the person who was wrongfully convicted, whose photo I showed you earlier, they didn't say that he was included as a potential contributor, but by calling it inconclusive, that left the door open for the jury to say, well, maybe it was, maybe it wasn't. And then by stacking these circumstantial pieces of evidence, the Crime Stoppers tip, the ski mask and the Halloween mask in the trunk, and then those nightclub eyewitness IDs all on top of each other, you end up with this conviction where this man who didn't commit the crime sits in prison until finally the Innocence Project picked up his case and they were able to represent him to a successful conclusion. But that is a pretty amazing set of facts to have come together to achieve justice for Mr. Grant. So some of the things that we talk about in terms of, I don't know how many of you watching this want to be trial lawyers someday or forensic scientists someday, but one of the things we want to keep in mind is that lawyers really have an obligation to understand scientific concepts if they're going to be criminal lawyers, at least enough to know how to ask for help and to have pre-trial conferences with their scientists. And prosecutors who are seeking justice have an obligation to understand whether the science that they're putting forward to the jury is valid and to respect the limits of the methodology. So if you're thinking about going to, as you're sitting in the beginning parts of your education, if you're thinking about maybe someday going to college for science or for law later, just remember that if you end up either as a prosecutor or defense attorney, for example, the responsibility that goes along with that is tremendous. And a lot of us, I mean, I'm a lawyer, so I can say this, I went to law school in part because I didn't do so great in science in high school and college. But what I realized is that I can learn enough sitting here today to know what questions I need to ask to make sure that the information that's out there is appropriate and that people understand what it is that they're looking at and don't mistake reality for TV. And even the gold standard disciplines like DNA analysis have certain areas of interpretation and subjectivity. And we all need to keep that in mind, whether we're sitting on a jury or participating actively in the criminal justice system. So some of the things we like to tell lawyers is if a case involves trace DNA, like for example, swabbing a handgun or swabbing a doorknob or something like that, everyone needs to proceed with caution in those cases. We tell our lawyers to always look at the notes that the scientists leave. There are national reports that get written about the quality of science and some critiques of forensic science. I have a couple examples here. And really, it's important, and this is true no matter where you are in your education process, to question results when you receive them. Make sure you understand what it is that you're looking at. And anytime we see a DNA result with a weak statistic or an inconclusive result, we talk about the need to question its value and to question how we arrived at that conclusion. And that is the conclusion of my presentation on forensic science and the law. So thank you so much for your time. And I'm happy to take any questions.
Lynn, thank you very much. That was helpful and interesting and I think reminds us that sometimes we overstate the exactness that science offers in the way of telling us what's right and what's wrong. And speaking of which, you talked about two cases in particular, one that concerned blood spatter and one that concerned DNA evidence. I know that there are other areas of science where there have also been problems that have arisen, where there's been a reliance, perhaps to a greater extent than should have been the case, on science to point in the direction of someone's guilt, when in fact there were reasons to stand back and be more cautious and not be as certain. Could you give us some examples of other kinds of science where we need to be a little more careful before we assume the science is absolutely right?
Sure. I think I'll give two different examples. One is an example where, frankly, the entire discipline is problematic on its face. So this would be bite mark comparison. And what I mean by that is, for a long time, a group of forensic dentists, a relatively small group of dentists around the country and in other countries too, but it was prevalent in the US, would look at an injury, a pattern of an injury left on someone's arm or leg or breast or something in the course of a violent attack, and then take a dental mold from a suspect and compare that to the bruising or the indentations left behind by that injury. Now, the problem with making that comparison is that the skin is highly variable, and injuries and the way they look change pretty dramatically as they heal. And so what we've seen is well over 36 exonerations in this country, including at least one in Texas, Stephen Mark Cheney's case, and that's a case out of Dallas. Very high profile case. If folks want to look it up, it's quite an amazing story. But what we see are situations where dentists would say things like, the chances of the bite mark having originated from anyone other than the defendant, Mr. Cheney, are 1 in a million. Or, it's with absolute dental certainty that I can say that mark originated from the defendant. And what we've seen through rigorous scientific experimentation and literature that's been published, and what we've seen be borne out in these dozens of exonerations, is that there's no basis for saying anything about a pattern injury compared to a dental mold with anything close to that degree of certainty. In fact, dentists have a hard time even agreeing whether an injury is attributable to a human bite mark or some other form of injury. Reliably, they have a hard time saying that, agreeing whether it's even a human bite mark, never mind who the bite mark came from. So that's one area that court after court after court finally are recognizing that the dangers of that type of testimony outweigh the potential benefits. And so they're starting to exclude it. So that's one example, bite mark comparison. The second thing that I would give an example, there's an exoneree named Richard Miles, who I think the Center for American and International Law has hosted before. And in his case, I think the primary driver of his wrongful conviction were problems with eyewitness identification, which we see a lot and which I'm not going to talk about here. But there was also erroneous gunshot residue testimony. So Mr. Miles, it was a shooting that happened at night near a gas station, from my understanding of the facts. And Mr. Miles was very young at the time, happened to be walking by and got ID'd, wrongfully ID'd, and was put into the back of a patrol car, is my understanding. And then they swabbed his hand hands for gunshot residue, and it came back with a positive finding. And I was actually just on the phone with Mr. Miles today about another program that we're doing together, and he said he remembers thinking to himself, how could it be positive? How could the results of that test be positive? I wasn't holding a gun at all. I hadn't even been near a gun. How is that even possible? But the truth is that those tiny particles, microscopic particles, can end up present on your hands because there's a lot of, there are guns that police carry, and there's GSR floating around the patrol car. Now, are you going to get a ton of it on your hands? Not necessarily, but if a tiny bit of it is reported out as positive, and they don't also say, well, that could be from any number of reasons, including but not limited to this list of 30 different things that could result in that positive finding, you're going to end up with a result that is very misleading to the trier of fact. They're going to think that Mr. Miles held the gun, was walking by the gas station, and somebody ID'd him. Well, that's how you go to prison for 15 years when you didn't do anything. Now, ultimately, he was exonerated. He's gone on to do these amazing, just incredible work on helping people re-enter when they've left prison, and has been recognized in various forums for the amazing work that he does in his nonprofit called Miles of Freedom. So, but that's another example. So that's a chemical analysis that crime labs do to this day that does have some value if properly applied. So unlike the bite mark comparison, where I would say it's just not an appropriate means of saying much of anything about what happened or who did something. I mean, you can say that injuries, there are obvious injuries there. And, you know, in child abuse cases, the worst of the cases, you could say by looking at a child's injury, that child was bitten, and prosecute the case. But to ID someone affirmatively using that information, I think, is problematic. Now, in the gunshot residue case, where you're doing a chemical analysis, that can have value if properly applied. So those are two other examples of things that we've seen. And there, you know, we have all kinds of different types of forensic science that are based, some on chemistry, some on biology. They're very interdisciplinary in their applied science. So they're exciting and interesting, and when used properly, have tremendous benefit for the criminal justice system. It's the used properly part, I think, that's key.
We owe you a debt, Lynn. The work that you do and the work that your commission does is vitally important to the criminal justice system. You may talk about it as being bureaucratic, but in fact, if the criminal justice system is a puzzle and we're trying to get the puzzle put together correctly, the forensic issues involved are often among the most critical pieces of that puzzle. So the work that you do, both to help ensure that the process is handled well by people who are well qualified, and that problems that arise are reviewed after the fact so that we can learn lessons and hopefully not make the same problems happen again in the future. That's vitally important work to the justice system. So please don't undervalue your role in making the justice system work. It's critically important.
Well, I appreciate that, and thank you for helping us get the word out, because some of the ideas are complicated, and there's science and physics and biology and DNA. What are you talking about? So we try to make it so everybody can understand the ideas we're trying to communicate.
Well, you do, and we are grateful for that. And I'd just like to close this by, on behalf of the audience that you're educating and on behalf of the justice system that you are assisting, thank you very much.
Thank you, Mark. Have a great day.
You too.
Rest of your day. Bye-bye.